Good morning, everyone, and welcome to Assembly Judiciary, Tuesday, April 5th. We do not quite yet have a quorum, but we do have some authors here, and enough to start as a subcommittee, so we'll begin as a subcommittee. And we'll begin with Mr. Gordon, which is item number 4, AB 2101. Mr. Gordon.
Good morning, Mr. Chair and members. In order to assure that our courts dispense justice in a fair and impartial manner, there must be rules of conduct for the courtroom. Judges regularly establish rules of conduct and are able to enforce these on most participants in a trial. Enforcement can be via contempt of court proceedings or a monetary fine. When it comes to jurors, the hands of judges are somewhat tied. The only recourse for juror misconduct is a contempt of court action. The judge has to suspend the immediate trial and conduct a separate action on the contempt situation. It seems that the trial court process would be improved if judges could sanction juror misconduct using a monetary fine. There are many forms of juror misconduct that can take place during a trial. These include discussing a case with other jurors, talking with members of either party of a case, researching evidence outside the court, and more recently, the use of social media to discuss the case. Social media use by a juror about their specific case can be a violation of the lawful court orders, but it can also jeopardize the integrity of court cases. Use of social media by jurors may be seen as a minor form of juror misconduct, but has become a significant problem in many courtrooms. AB 2101 would create a pilot project that would temporarily add impaneled jurors to the list of persons subject to reasonable monetary sanctions in both criminal and civil cases for violations of lawful court orders done without good cause or substantial justification. The Judicial Council of California would be tasked to solicit the participation of a representative sample of courts to take part in the pilot. The Judicial Council would also be required to conduct an evaluation of the use of the pilot program and report results to the governor and legislature on or before July 1st, 2021, with a pilot set to sunset on January 1st, 2022. This bill is needed to test the efficiency of reasonable monetary sanctions as a way to hold jurors accountable and deter them from violating lawful court orders. I want to thank the committee for working with my staff to help craft this as a pilot. Adding jurors to the list of persons subject to reasonable monetary sanctions will prevent delay in cases over minor juror misconduct, while also allowing a judicial officer an additional tool to protect the integrity of the case at hand. I would respectfully ask for an aye vote.
Thank you. Your first witness, please.
Yes, Sharon Riley on behalf of the Judicial Council. We are the sponsor of the bill. And I would like to thank Assemblymember Gordon and his staff, as well as the committee staff, for working with us to craft the pilot. Today I have with me Judge Cousins, who's the vice chair of our Criminal Law Advisory Committee. That's the committee where this idea came from. So I will turn it over to Judge Cousins now. Thank you.
Mr. Chair and members of the committee, thank you for this opportunity to speak. I am Richard Cousins, retired judge from Placer County. I have been on the bench now for about 40 years. I'm still actively sitting. And this is the little problem that comes up every now and then, as indicated by Assemblyman Gordon. It's an important tool that we would have to add this ability to impose sanctions rather than the draconian contempt process. And because it's a pilot project, it'll allow us to fine-tune it. And I certainly appreciate your aye vote, and we'd be happy to respond to any questions. Thank you.
Thank you. Is there any other witnesses in support? Seeing none, is there any opposition? Seeing none, I'll bring it back to the committee. Questions, comments? Seeing none, Mr. Gordon, you may close.
Thank you. When you have a quorum, I would respectfully ask for an aye vote.
Thank you.
Thank you.
No quite quorum yet, but the recommendation is due pass, and the bill would then go to appropriations.
Thank you.
Thank you. So next we have Mr. Ridley Thomas, item number 7, AB 2707.
Yes, thank you, Mr. Chair. I am bringing AB 2707 to you that is addressing a novel problem that we have in retail environments in this state and across the nation. It's a phenomenon called consumer racial profiling, and it targets a particular community pretty heavily in the retail environment, the African American community. Imagine that you are on a train with a group of your peers, and you're adults and you're enjoying that train, maybe a wine train in the Napa Valley, and because it is perceived that you are not fit for that environment, you are removed from that train unceremoniously. Think about the indignity of that encounter. Think about the anxiety that it might cause. Think about the disrespect that you might feel. Imagine that you go to a retailer and you seek for goods and services, goods in this case in the retail environment, a large big box retailer or a luxury retailer. And for some reason you find yourself being either followed or tracked or harassed at the exit points or at the cashier with suspicions of theft. Believe it or not, the Gallup and the Center for Popular Democracy and various entities find that African Americans are 7 times more likely to be profiled for potential theft in the retail environment. And AB 2707, I think, is an appropriate response to that terrible phenomenon. It amends the Unruh Act to add this definition to this insidious practice that is consumer racial profiling. Now, we know that the Commerce Clause of the Constitution and the Unruh Act itself regulate commerce pretty aggressively, but there are current deficiencies in law. We need protections for consumers. We need to make sure that the practice of consumer racial profiling is ended and that companies take policies, small and large retailers take policies to ensure that no one believes that it's appropriate to profile someone based on race. I would add, and there may have been a report I think you all have from the Zara USA example, but I would add that, in fact, those who are most targeted, African Americans in this case in the retail environment, are very low on the scale of those who are likely to actually engage in shoplifting, which is the unique suspicion. And we simply need to address loss prevention models and theft prevention models at these large retailers. We think this is an appropriate approach. So the bill, as written, adds that definition, gives Fair Employment and Housing the responsibility to follow up on suspected claims. We think that this will change the behavior and be a significant deterrent in what I mentioned earlier is a rather insidious and unjust practice. With your indulgence, Mr. Chair, we have witnesses that can attest to the unique experiences of those who have been profiled in the consumer and retail space. Thank you.
Thank you, Mr. Ridley-Thomas. Your first witness, please.
Mr. Chairman, members of the committee, my name is Shea Crowder, and I am a politics PhD candidate at Princeton University. Last year, I was the Social Justice Research Fellow at the Center for Popular Democracy, and I'm the author of the report placed before you. I'm pleased to testify in support of Assembly Bill 2707. So last year, I was a social justice research fellow at the Center for Popular Democracy, and as such, a part of my responsibility was to conduct an independent research project. My independent research project focused on the experience of particularly workers of color at Zara stores across New York City. Zara is the world's largest fashion retailer. They have a very large international footprint, and their footprint is growing here in the United States. During my time working with workers, I surveyed them and interviewed workers of color, and as well as white workers. And a term that repeatedly came up was the term special order, which was something that I wasn't familiar with. And so upon further investigation, the workers, they defined this term as a code used when someone suspicious or a potential thief walks into the store, and it was a sort of loss prevention technique. While my survey and my report primarily focused on looking at the experiences of workers as it related to discriminatory practices in hours and promotion, this was one of the findings that was kind of latched on to by the media when the report came out this past summer. I surveyed workers and asked what demographic of people were most likely to be profiled or deemed as a special order upon entrance to the stores, and I found that black shoppers were 7 times more likely to be identified as special orders upon entering the store and to be identified as potential thieves. This was particularly troubling for a lot of the workers of color because they felt that they were put in a position to where they had to target, identify, and follow people that they would otherwise identify with as their peers ethnically and culturally. Additionally, I'm sure I don't have to say much to indicate how troubling this is to find out for potential customers as well. I'd like to thank Assemblymember Sebastian Ridley Thomas for having the courage to address this important issue before the California State Legislature. Thanks so much.
Thank you. Next witness, please.
My name is Pamela Price. I'm the Director of Special Projects for the Lawyers Committee for Civil Rights of San Francisco Bay Area. I'm here today at the behest of Assemblymember Ridley Thomas. The Lawyers Committee sponsored this legislation for good cause. We have received information that is consistent with what has just been presented to you. With respect to the racial profiling of African American consumers. Over and over, we receive reports from particularly women who shop in local stores that they are followed, and men as well are routinely followed, and often have an experience where they're brought back falsely accused of having stolen something, detained, and then let go as if nothing had ever happened. But the impact of that is quite devastating. In 1979, the California Supreme Court recognized that in California, the conduct of privately controlled and employed security personnel goes far beyond the limits of what they would normally be, that they pose a threat, in the words of the California Supreme Court, to the security rights and the privacy of Californians that's comparable to that which may be posed by the unlawful conduct of police officers. That case is called People versus Zelensky. Since that time, the problem has only grown larger. If you think about it, private individuals acting as agents of retailers, a la George Zimmerman out of the Florida situation, Fourth Amendment protections do not normally apply to them. And so a private security force is generally employed at every mall that you go into. And in one situation, the Santiago case involving the Coronado Mall, that mall had 150 stores, over 1.1 million square feet of space, 5,400 parking spaces, 19,000 employees, and more than 12 million people a year visit the mall. One of the witnesses that we brought here today is Colleen Tiffinson, who will talk about a store, an experience that she had at Kohl's store, which is at South Shore Mall in Alameda County. And she will tell you how that impacted her. And as a result of having been falsely accused and detained, she no longer wants to go to the mall at all. So this is a problem that not only affects consumers, but it affects retailers. Under California law, we have the merchant's privilege, which allows private security to stop and detain consumers. The question is, what triggers the stop? Is it your race? And unfortunately, that happens far too often. Once the consumer is stopped, then there's very few restrictions on there are legal restrictions on what can take place, but the standard is one of reasonableness. Under California law, consumers are not supposed to be searched by private security people. Only items in plain view may be seized, but often consumers are unaware of their rights. So their person is searched, their belongings are searched, and they have no idea that their rights have been violated. And that's something that needs to be addressed, we hope, under AB 2707.
I'm going to need you to wrap up.
All right.
And
That's
Yes.
fine.
thank you. And you mentioned someone else who wanted to give
Yes.
testimony. I'm going
Colleen
to allow
Tiffin.
one more testimony, so if she would come up, and then everyone else will just give their name and indicate their support.
Yes. Oh, it doesn't. The chair.
My name is Colleen Tiffinson. Go ahead. On Sunday, February 20th, 2016, I was falsely accused of stealing from Kohl's department store as a result of racial profiling. Loss prevention staff illegally detained me, subjected me to a barrage of threats, intimidation tactics, and assault of my moral character. This happened in spite of my vehement protests. My purse was searched. Nothing was found to substantiate their allegations of theft. Store management at the local and corporate level was evasive, uncooperative, refused to provide any documentation, and basically acted as if the incident never occurred. In the weeks since my public humiliation, I continued to experience bouts of diarrhea, panic attacks, fits of trembling, and headaches when I recall the incident or find myself in proximity to the store. I have been left with no choice but to end my long-standing patronage of all the stores within South Shore Center, Alameda. One aspect of the experience that haunts me the most is the way Kohl's co-opted the role of the police and made it into a sinister threat rather than a source of help in a difficult situation. The picture they painted of what would occur should the police department become involved was terrifying. In a just world, a citizen being accosted would have the right to call the police without this fear. I was left vulnerable without a protector. I have been forced to question my personal freedom, safety, and self-esteem in this world. It is very humbling to think that the high regard in which I hold myself and believe others see can be blinded by a negative racial stereotype. Kohl's has made me another statistic of the racial bias and divide that continues to infect this country. That is why this legislation is so important, hopefully to prevent such violations from occurring, for the retailers to have some culpability for their actions, and for individuals like myself to have recourse.
Thank you. Is there anyone else in support? If you could come forward and just give your name and affiliation. Seeing none, is there any opposition? Seeing none, questions? Mr. Chow.
Thank you, Mr. Chair. I just wanted to say that I will be supporting the bill today.
Thank you.
Yet I understand that the bill will be going to privacy committee, and I want to reserve the right to take a close look at the privacy aspect as well as the implementation phase of this bill. So I want to thank the author for bringing it forward.
Thank you for your consideration, Mr. Chow.
Ms. Ridley Thomas, I want to. Oh, Mr. Gallagher, go ahead.
Assemblyman, one question I had was on the definition of consumer racial profiling.
Section 1, line 8.
Yeah.
There's part 1 and part 2.
The second part where it
Yeah.
It says consumer racial profiling also includes but is not limited to refusal to serve, removal from the business establishment, segregated seating, requiring additional forms of identification, and race-based surveillance practices.
Right.
I was just, when it comes to, there may be reasons to refuse to serve or to remove from an establishment that have nothing to do with. So I'm saying, shouldn't in this definition be where that happens due to a racial bias or racial intent?
Yes, it's
because if it's just, if it's just blanket, any removal, any refusal to serve, there might be legitimate reasons why someone might be refused service at a. Yes, have nothing to do with race.
Part 2 is in relation to part 1. Those are simply examples as it relates to part 1 in the actual the definition. So it's just a teased out version of the definition with the examples of practices that are unacceptable.
So that would relate to 1?
Yes, it's related to 1. It doesn't stand separate from 1.
Right. Where it's differential treatment based on race.
Correct.
Or ethnicity.
That's the test.
Okay. Yeah, it just didn't seem real clear there because it almost seemed like that was a second definition. So I just, if we can clarify that.
The also is the connective portion of that.
Okay.
Yeah, it's not more expansion. It's simply further clarification.
Okay.
Mr. Wagner.
I listened to the evidence. Zara's is a New York facility, and you talked about New York experiences. I think the witness, you've got a lawsuit against Kohl's for false arrest. I mean, there are remedies for what you told us about. So I'm not entirely sure, and maybe the author can address how this bill solves the problem in New York or solves the problem short of a lawsuit against Kohl's. Because I'm not seeing the connection to the witnesses.
And practicing attorney Price can talk more about outstanding lawsuits. There are several major retailers in this state that have loss prevention schemes that have either provoked consumer unrest or lawsuits currently. The thing that I think it's important for us to understand is because of the nature of our work, we probably don't shop that much in such retailers. If we do, it's probably a limited period of time. It is likely that in the course of this bill, should it move forward, that my constituents of yours, relatives of mine, will be subject to consumer racial profiling if they go to a jewelry store and may be suspected of opposing some threat simply by the way that they look. And sometimes, and this is in, I think, the report as well, is there is a greater fear, believe it or not, among the consumer community of these strange loss prevention schemes than of police misconduct, because honestly, law enforcement can be your only saving grace as a neutral arbiter in that moment when you are detained. So it's been my observation, personal experience, and that I am sure that if this bill goes through the entire process, my mother will at least be subject to consumer racial profiling if this is to go throughout the remainder of this legislative session. That's how pervasive this issue is. And it's at retailers large and small, but the bigger retailers that have the more aggressive loss prevention schemes are the most egregious.
Okay. So let me ask about a retailer that has an aggressive loss prevention program,
right, and
is in fact following someone of color who's come into the store, never stops them, never accosts them. I used to do, when I was working my way through college, undercover retail security. You never talk to the person.
Nope.
As far as you know, you don't even want them to know you're watching them.
Ideally.
Is that still actionable under this? Is that actionable?
No.
Okay, so what's the level? If that's not actionable, what physical thing has to take place for it to be actionable?
If you physically followed someone or made them feel uncomfortable. So if the consumer feels as though, and what we suspect, the reason why we want Fair Employment and Housing to do this is because it ferrets out nebulous claims. You won't see shoplifters, serial shoplifters, who go to Fair Employment and Housing or go to an attorney and say, retailer X. And we don't want to call all the names because it's everybody who has significant operations in the retail environment in California. Everybody has an issue. And what this bill, we suspect, will do is change policy. I'm not interested in extensive litigation. I don't want this to I don't want to explode the litigation environment. I want it to be a significant deterrent so that someone realizes that someone's mother, that's someone's daughter, that's someone's wife, that's someone's significant other, that's a community member of value, that is a human being that deserves no less than full respect and treatment. And if they're African American, they are significantly less likely to actually be involved in shoplifting. That's the crazy thing about it. That's the thing that screams that you must have policy that highlights the issue. So, frankly, there are protections under law. You can go to court.
Right.
However, consumer racial profiling is not very, because we think about accommodations and we think about lunch counters and whether or not you'll be served at a lunch counter, because we're talking about desegregating services. So you can walk in the door, you won't be escorted out or prevented from entering the facility, but if you are going to the jewelry counter or to the women's clothing section or to buy someone in the men's section something else, and these are overwhelmingly women. That's why I went to the train example, which would be an example of this. It disproportionately impacts women, and it causes anxiety, and it really has developed to the point that it requires some level of governmental response. I would rather that we speak to it rather than the courts.
Okay, so I'm clear. As long as the individual feels as if they've been watched or profiled in some way, even though the retailer may have taken no action, and certainly no other action, doesn't stop them anything. As long as the consumer feels they've been watched, there's an action under your bill.
They have the ability to, if it's found by fair employment houses, because we're saying, hey, we're not choosing in advance. We know anecdotally, we know through new research that if you investigate it, our friends in the retail environment will be embarrassed by how deeply and ineffectively their loss prevention system works. And
wouldn't that be a better answer? Let's go embarrass them.
Without question, but I think that this will spur corrective action. So we'll see broad-based cultural competency improvements, in my opinion, and it is likely that this practice will significantly decrease.
All right, thank you. We're going to pause for a second and establish the quorum.
Stone?
Here.
Wagner?
Here.
Alejo? Here. Chow? Chu? Gallagher? Here. Weber? Holden? Here. Mainshine? Here. Ting.
So we do have a quorum. So, Mr. Ridley-Thomas, I mean, one of to answer to Mr. Wagner's question, it's the Department of Fair Employment and Housing that brings the case, not the individual.
Correct.
So
ideally,
there is a bit of a filter there. And I do think in looking back on this that Mr. Gallagher has a point with respect to the provision that he brought up. And I might suggest that we take that language, differential treatment based on his or her race or ethnicity, and just add that into the second section there. I don't think that thwarts what you're trying to accomplish, but it also clarifies that, because I think what's important in this bill is that that treatment is different based on that somebody's receiving differential treatment based on race or ethnicity.
So you simply want to repeat in Section 2 the definition in Section 1? The also is insufficient in your mind?
Yeah, we could. Yes.
Okay.
I think that's a clarification that doesn't frustrate the purpose, but clarifies what you're trying to get at.
Yeah, for the in the spirit of,
because otherwise you're creating two categories, and that's something that if you agree to that, you can take in privacy.
Yeah,
committee, because that's
no
the
problem,
next committee
Chow,
that you're going to, and I think that's the point. And to the discussion here. We, in our culture now, we've become numb to or blind to racism. And I think that's very clear. We don't talk about race very much. We don't point it out when racism is happening. We don't stand up for those differences. We've lulled ourselves into this notion that we're no longer a racist society when, in fact, we are. Yeah. And that's why I agree with your approach here. And the way that you're proposing it is creating that statement of differential treatment for someone who walks in this door, and it's purely just based on what they look like, no other attribute. That's indefensible activity, and it should not be tolerated in California. But yet we know through the research that it tends to happen. So I appreciate you bringing this forward, and hopefully that if you understand that clarification, I think that helps the argument that you raised in answering to Mr. Gallagher's question, that if that was intended to be linked, I think clarifying around that, so we're not creating effectively what it potentially creates is two different definitions without that linkage, that really what we're talking about is that differential treatment.
Well, Mr. Chair, I appreciate the suggestion, and we'll come up with a couple of suggestions and keep the committee, should we move past this point, keep the committee in the loop on how to proceed. But
thank you.
It stands to reason.
I think it's pretty straightforward.
Yes, it is.
Yeah. Okay.
You don't need to.
See no other questions or comments? Mr. Ridley-Thomas, you may close.
You closed better than I could, Mr. Chair. Respectfully request an aye vote.
Thank you. And I am looking, we do have a quorum, so I'm looking for a motion. This is item number 7, AB 2707. So we do have a motion and a second. The motion is due pass to privacy and consumer protection.
Stone?
Aye.
Stone, I. Wagner? Wagner, I. Alejo? Alejo, I. Chow? Chu? Chu, I. Gallagher? Gallagher, I. Weber? Holden? Holden, I. Mainshine? Mainshine, I. Ting.
That bill is out.
Thank you so much, Mr. Chair and members of the committee.
Thank you. And we have also heard item number 4, which is AB 2101. The recommended action is due pass to appropriations. I'll take a motion. We do have a motion and a second. Call the roll, please.
Stone?
Aye.
Stone, I. Wagner? Wagner, I. Alejo? Alejo, I. Chow? Chu? Chu, I. Gallagher? Gallagher, I. Weber? Holden? Holden, I. Mainshine? Mainshine, I. Ting.
So that bill, Mr. Gordon's bill, is out. We also have a proposed consent agenda, items 11 through 14, AB 1639 Mainshine, AB 1911 Eggman, AB 2263 Baker, and AB 2458 Obernolte. I'll take a motion on the consent. We do have a motion, and we do have a second on consent. Call the roll, please.
Stone?
Aye.
Stone, I. Wagner? Wagner, I. Alejo? Alejo, I. Chow? Chu? Chu, I. Gallagher? Gallagher, I. Weber? Holden? Holden?
Consent.
Holden, I. Mainshine? Mainshine, I. Ting. Ting?
Mr. Ting, consent?
Consent?
Mr. Ting, consent?
Ting, I.
Those bills then are out. I guess Mr. Bonta stepped out, so that takes us to Mr. Lackey. Item number 3, AB 2003.